The formulation of a remedial strategy should pay close attention to the dynamic between the parties to the litigation. To begin with, the kind of remedial relief sought might depend on whether the government is being held accountable for its failure to realize the right to education, or whether a private provider of education is being held to account. In accepting an offer to settle out of court, litigators need to be confident that the government or private provider of education will fulfill their obligations under the right to education. In this regard, a careful balance needs to be struck between the interests of the clients in settling out of court and the strategic importance of obtaining a judicial precedent to build on in future cases. We now turn to consider this question of how litigators manage the dynamic between the parties to public interest litigation.
Yes, the remedy would differ based on whether compliance is going to be from the government or from private parties. Now in India, there is a huge amount of litigation going on where private schools are involved because private schools have been challenging their coverage under the Right to Education Act. Often private schools claim to be minority schools so that they can get exemption from coverage of the Act. And in many cases, there are learners and children who seek admissions in private schools where they have been denied admissions. And so remedies would differ. If they are private, if remedies are sought against private schools, then very direct remedies are sought, such as giving admissions to learners or ensuring that particular private schools comply with requirements under the Act. But if compliance is to be done by the state government, the relief sought or the remedy sought is often much broader or larger structural remedies because you do not want to limit the scope of the government, and it's usually to seek larger or broader implementation of the law, sometimes even broader interpretation of some sections of the law where such broader interpretation may help or increase coverage of the Act.
I think that when we are seeking an order against the state, we are always conscious of the fact that you are dealing with a situation where two arms of government are interacting with each other, and the court has an obligation to pay deference to the executive. This is not a constraint when ruling against private actors. At the same time, it is the state who bears the principal, sometimes exclusive obligation to ensure that constitutional rights are both respected and realized, and so we cannot make orders upon private actors where those obligations do not extend to them. Representing a social justice movement, settlement offers can be quite complex. I recall an instance where we were trying to ensure that the minister enacts certain regulations, and after she delayed and there were months and years of a delay, she requested a further extension as part of an existing settlement agreement. And what Equal Education in fact had to do as a movement was go back to their members and source their members' opinions in order to make a well-informed and democratic decision on the issue. Ultimately, it was decided to give the minister a month's extension, but it was quite a lesson in how settlement offers were going to be deliberated on with client.
Well, on settlement, since we have very often what I'm dealing with are big ticket items, settlement becomes difficult, and it's also a question that there's a lot of politics in this, and I see these law reform efforts very much being involved with political reform and advocacy issues. So even if you get a governor or a legislature at a certain point in time to agree to something, it's very critical to do it in a way that you're binding their successors and all. Also, sometimes you don't know the full potential of what the case may bring. I remember in our CFE case early on, we had a conversation with the directors of the organization, and somebody said to me, Michael, if the state offered us $100 million for New York City schools to settle this case, what do you think? Should we take it? And that was very early on when we thought we had a small chance of winning. I said, wow, if we got $100 million, I would recommend taking it. Well, our eventual settlement was $5 billion. So that would have been a very poor deal, and I'm glad the state never actually ordered it. So I'm somewhat skeptical of settlements, and I know in the disability case that I mentioned earlier, we had various settlements along the way with the Board of Education, with the state, and then we found as the case went on, we'd partially settle an issue, and then as the needs developed and as the understanding of the education issues developed, a lot of the things that we had all agreed to became minor issues in a larger context, or became undermined for one reason or the other. So I haven't had too much success with settlements, let me put it that way.
In India, mostly we do not have a situation where we have settlement offers in public interest litigation from the government. There are very rare cases where the government comes forward and agrees to settle a case. We not yet had it in a right to education matter. Often the government sometimes concedes and states that it will comply with the order, in which case if the government agrees to our claims, then we usually ask the court to allow such a claim with a time limit, so that if the government actually backs out of its compliance, we have the opportunity to file a contempt claim as well.